Welcome to Sakshi TV's special immigration show with attorney Ms. Prashanthi Reddy from the law offices of Prashanthi Reddy PLLC. Ms. Prashanthi needs no introduction, but if you need consultation, please log on to reddyesq.com for contact information. And when you connect with them, do not forget to mention Sakshi TV. From the beginning, reddyesq.com's site has put a wealth of free information and online tools in the hands of immigrant community and for the benefit of US employers. The reddyesq.com site provides you with latest and cutting-edge information on US immigration law and policies explained in terms you don't have to be a lawyer to understand. Today's topic is the I-485 updates. We will continue the knowledge session along with the news and updates on latest immigration, followed by Q&A. Before we for tips, hi Ms. Reddy.
Hello, hi Tony, how are you?
Show. Hope you're doing well.
Thank you. I'm good, thanks.
So, Ms. Reddy, before we get on to the topic, do we have any latest immigration updates or can we get started with the show?
Let's get started. We have a lot of updates.
Right. So, we've gotten information that the House is going to vote on the Eagle Act today. So, what would you want to tell us about that?
Yes, that's breaking news. For those who are eagerly waiting for their visa numbers to become available, for all those who have filed a 485 or who have an I-140 approved, but whose priority date is not available, so they cannot file a 485, or there are a lot of people who have filed 485s in 2006, 2007 and still waiting because their dates retrogressed. Just to backtrack a little bit, as we all know, or if you don't know, the entire, green card immigration system is severely disadvantages Indian and Chinese nationals simply because every country has a 7% cap on the number of green cards that can be filed, from that country. And because the demand is so high for China and mostly Indian nationals actually, that for someone, say from Iceland, they could get their green card immediately because their visa numbers are available for that country because it's such a small country. But a large country like India, or for that matter China, since the demand is so high, it can take up to their whole lifetime. And I'm not exaggerating. If it goes as it's going now, it can take up to their entire lifetime. And someone has calculated it as 84 years. I don't know how accurate that is. For someone who files today to get their green card, unless there is some intervention or, something happens. So, that's the background.
And the visa related to the fact that China and India are both largely populated, with India being the first most populated country in the world.
Right. So, and also because the usage for Indian nationals is more, there are a lot of immigrants coming in from India who qualify for these employment-based petitions. So a lot of them come on H1. So it's even more for India.
Is that so? Right.
Yes, it is. Okay. So it's actually most backlogged for Indian nationals, and then China, and then rest of the world. So there has been some attempts to equalize that, and several bills have been introduced, but nothing has happened. Some bills have come really close to getting passed, but due to time constraint, etc., it couldn't be passed. But now coming to topic. Today, so this Eagle Act, which is going to be voted on today in the House, I hope, that's the news that we heard, was introduced in the House in June of last year, and EAGLE stands for Equal Access to Green Cards for Legal Employment Act of 2021. So that's EAGLE acronym, so this was introduced by a representative of the House from California, Democrat, called Zoe Lofgren. Now he's the same person, by the way, who introduced the previous bill that we had on this matter, but we'll talk about that later. So the bill seeks to equalize green card backlogs by eliminating per country caps for employment-based visas. So as I said, right, there's a 7% cap on each country, and that's it's very unfair because some have more demand and some don't even use up the numbers that are given to them. So this bill also has some provisions reforming the H-1B specialty occupation program, and also gives some flexibility for those already in the US and are stuck in the green card backlog. So it's very similar to, this bill is very similar to the Fairness for High Skilled Workers Act, which, if those of you who recalled, who've been watching this news closely, was introduced in 2019 again by the same person who introduced this bill, Representative Lofgren, and it actually passed the House, and then there were a lot of negotiations and compromises made in the Senate, and it was amended 4 times. I'm talking about the Fairness to High Skilled Workers bill.
Right.
And by the time it was time to again bring it back to the House and pass the revised version, unfortunately the time was out because it was the end of the year, and the Congress 116th Congress session had closed, so they would have had to then start all over again. So they didn't do that. So instead now they've pretty much introduced a very similar bill, and it's called EAGLE Act instead of Fairness for High Skilled Immigrants, but the provisions are pretty much the same. Let's go through the provisions quickly. One is phase out of per country caps, so that's 7% caps for employment-based green cards. They want to remove it completely so that it's first come first serve, and so everyone who waits. So some people don't have to wait for decades to get their green card, while others, get their green cards as soon as they're filed. This would also raise instead of removing the caps completely, it would increase the cap for the family-based green card from 7% to 15%. Employment-based, excuse me, it removes the cap completely. But before they remove the cap completely, there's going to be a transition period. Now they're concerned that suddenly the rest of the world who has never had backlogs or has insignificant backlogs in the past, not as significant as India or China, they don't suddenly find themselves heavily backlogged. So in order to transition it, they have said that they will do it slowly. So they will wait for a period of 9 years to ensure that applicants from the rest of the world, kind of phase it in slowly. So in the first year, they will increase it by 30%. They will make a reservation for rest of the world for 30% of the cases. They'll reserve it. Then it's 25% the next 3 years, and then 20% in the last 3 years, and then they'll phase it out completely. So they reserve a certain number of numbers for the rest of the world, so they don't suddenly get completely backlogged. And at the end of the 9 years, they'll remove that reservation completely. So it's a phased-in approach. Also, what they're going to do, or what they want to do, is provide a new status for some non-immigrant visa holders that are waiting for green cards. So a lot of now during this phase-out period of 10 years, a lot of people might still face, Indian nationals and Chinese nationals might still face a backlog, and they might still have to wait for years and years before their 485 can be filed. So what they would do is they're filing a perm, filing an I-140, and just sitting tight. And sometimes, so they have to continue to be on H1 for that period of time. And it's very onerous to be on H1 for such a long period of time, because the H1 rules are very, very strict, and are very, heavily favor employers and don't really favor the employee. So they're providing a new status, which would be called early filing or early adjustment of status. And this would permit individuals to get all the benefits of a 485 filing, but not actually get the green card. So they would be able to travel more easily, perhaps using advance parole instead of having to go to the consulate for a visa every time, and get rejected, then they won't even be able to come back into the country. So to avoid that, they will be given expanded travel rights. They will applicants who have filed their I-140 and who've been waiting for at least 2 years, would get these benefits. They would also be allowed to change employers, and same way that people who presently have a 485, they are able to change. These people will be able to change also. So it gives you puts you on par with the people who have filed a 485, but doesn't. And so it's better than being on a H1. So it's a little bit of a relief for them. And also, most importantly, allows dependents to have the same flexibility and prevents children from aging out. Right now, most children who are not born in the US are aging out because their parents are not getting a green card before they turn 21 because it's taking so many years. And they are finding themselves having to go back on an F1 and then go through the entire process themselves, even though they've waited most of their lives. They've filed a petition, their parents have filed and they waited, but they'll have to start all the way from the beginning. Another program would be the H1B program. They always, when they give benefits, they like to take away some things. So the negative connotation for this bill would be the restriction on H1s. They're talking about basically H1 employers having to advertise on the Department of Labor website before they file a H1. They can only do it then if they don't get any responses, almost like a green card. And employers who have more than 50 people in their company, so those employers who have over 50 employees and 50% of their employees are on H1, they will not be allowed to file H1s, something like that. So they're carving out these restrictions. Let's hope that part doesn't come through and the good parts come through. And they're also carving out some benefits for nurses, because right now there's no real way for nurses to come into the US. So they're creating a program for nurses to come in, which is great because of the shortage in healthcare and the necessity because of COVID. So that's the Eagle bill, and we don't know yet with reference to the voting. I will keep you updated on what happened with reference to the voting in the next segment.
So, like you already said, Ms. Reddy, we do have a lot of updates to catch up with. The next being the Jumpstart Act being introduced. So, could you please start over explaining to us the Jumpstart Act?
So, the Jumpstart Act is also is with reference to the visa numbers and the non-availability of visa numbers, and trying to make these green card numbers available to Indian and Chinese nationals. So that's a new bill. It's separate from the bill that that we are seeing, and it's a little different from the previous bill. So this bill provides a mechanism for individuals to apply adjustment of status, so again, it talks about recapture of unused immigrant visa numbers, and creates different sections. So one section is 245N. They've created a new section where a person allows an individual who is eligible for adjustment of status but is waiting for a visa number to become available to submit an application for adjustment of status if such an individual pays a certain amount of money. So again, it's very similar to the previous bill. So they're saying that you have to pay 1,500 if it's a family-based petition, 3,000 if it's a employment-based first, second, or third petition, and 15,000 if it's EB5. So that's a new bill introduced. So it'll allow people who have filed an I-140 to file a 485 and get all the benefits of a 485, even though their visa number is not available, for an additional fee. The second aspect of the bill is that it will allow basically people who have been waiting for a period of 2 years, it will allow them to waive the per country worldwide limits on immigrant visas. So it will allow them to file a green card and get the green card even though their priority number is not current. as long as they wait for a period of 2 years after the I-140 is filed. So one aspect is allowing the 485 to be filed, and then the second aspect is if they've been waiting for 2 years and their visa number still doesn't become available, their country cap will be removed completely, and they will have to pay a certain amount of money again. Family based 2,500, employment based 7,500. This is very similar to the Build Back Better bill and the previous bills that have come, with slight deviations. I'm not quite sure why so many bills have been introduced on the same topic, but it is what it is. And it's better for us, because if one doesn't pass, then the other one is in line. So they're trying to get this visa number bill passed before before elections again, because then we don't know, once midterm elections happened, whether Democrats will still have a majority or not, and it might be much more difficult then for them to pass any kind of immigration bills.
And the next update would be about the service center changes. So what would you like to add to that?
So this is a practice, basically a practice alert. Right. USCIS has right now when we're filing 485s, we send them to certain service centers, Nebraska or Texas, depending on the address and depending on whether the I-140 is filed or approved, etc. So based on that, we send it to different service centers, and there's a criteria on which service center to send it to. And most of our viewers who are aware of the situation know that the National Benefit Center is the one that processes. When they get transferred to the National Benefit Center, usually their cases get processed quickly. So now what has happened is, as of February 17, 2022, basically USCIS has said that all cases are going to go to the National NBC, to the National Benefit Center. And a transfer notice will be issued to the farm, to all those people, telling them that the case has gone to the National Benefit Center. Now, cases already with officers, that means live cases that have already been, where the adjudication has already started, those will be adjudicated, continue to be adjudicated by Nebraska and Texas service centers, such as, cases where requests for further evidence has been sent, etc. And then once they've been pre-processed, then they will be shipped to the NBC. Right now, Nebraska has not given us a time frame for how quickly these cases will be, transferred to NBC. But informally, there's been an indication that approximately 1,000 cases per week are already being shipped, and they're expecting a sharp rise. Now, members are also reporting that they've started receiving transfer notices. But of course, we didn't know at that time that this was a policy change. We thought it was just a random movement of cases, which even have happened earlier. They keep, USCIS keeps moving cases back and forth to different service centers depending on the workload. So we thought it was that, but actually it seems like it's a policy change. So how does this affect existing cases? So pending cases that have been actively adjudicated will remain, as I said, with their current service centers and will be moved once the pre-processing is completed. Employment-based cases transferred to the National Benefit Center will generally be relocated to the field office for final adjudication. So that means we can expect field offices are where the interviews take place, but it's not necessary that if it goes to the field office that an interview will be deemed necessary. There could be a waiver as well, and they could just adjudicate the case without an interview. And there's no indication of how processing times will change. This is the most important question in a lot of applicants' minds, because already there is such a huge backlog. And now if all the cases are being sent to just one office, I don't know what's going to happen. But since, as of now, all the cases will be adjudicated at NBC, we can't say how it will affect the processing time. NBC has said that they do not need additional staff to process this new workload. And I'm very surprised with that because now they're going to have 4 times the workload. And how will the present staff then do it? So that's something that I don't quite understand. But they have said that priority will be given to cases that are current and priority will be given to EB1 cases. So we can expect, I'm hoping, movement on cases that are current. We can only hope. We don't know what will actually happen. So those are the updates that I have for the 485s.
Right. So now that we've covered the updates, should we move on to the questions, Ms. Reddy?
Yes, please go ahead.
Right. So we have some I-485 FAQs, and I'm just going to ask you those. So the first question would be: should one maintain the non-immigrant status after filing for I-485?
Yes, I think it's a good idea to do that, especially if you have dependents who might be aging out, because if you do not maintain, so if you maintain it, they'll be on a H4, they continue to be on a H4, and then if they age out, then they will be able to move from a H4 to an F1, to a student status. So it's easy, the transition will be easier. But if you give up your non-immigrant status, and if you have dependents who age out, then they will pretty much fall out of status. So they will then have to leave the country and then apply for an F1 visa at the consulate abroad. So it's a little bit more difficult and also more risky because they might not, if their visa is denied at the consulate, then they will be stuck outside the country. So that's one reason why you would maintain your non-immigrant status. Another reason would be is if you depend only on your 485 and you give up your non-immigrant status, it could be that your 485 gets denied because, usually the 485 doesn't get denied, but if there are some issues, for example, if your I-140 is not yet approved, I would definitely not give up my non-immigrant status because the chances of an I-140 denial are much higher than the chances of a 485 denial. So I would at least wait until my I-140 is approved. And even after that, everybody makes their own judgment on it because there's definitely benefits on being in a 485 pending status, as you can move employers much more easily. You don't have to maintain your H1 status. The terms and conditions of maintaining a H1 are much more onerous. You can work for anyone really on a 485 as long as you follow the rules and notify USCIS of the change in employer and the job is the same. So there's much more job flexibility. So there's, you have to weigh the advantages and disadvantages and then decide whether you want to give up your non-immigrant status or not. But in general, if you don't have kids who are aging out and if your I-140 is approved and if you don't have any reason to believe that your 485 will be denied, like issues with status, maybe some criminal issues, stuff like that. So then you can, not a bad idea to move completely to a 485. Also another thing to remember is if you move to a 485, then if your dates become current on your EB2 and you've presently filed on an EB3 and you have an EB2 I-140, you cannot then refile another 485 for EB2 because you don't have the status to file another 485. But you could interfile in that situation.
Right. So moving on to the next question, Ms. Reddy. What if a person is laid off before getting the green card while their I-485 is still pending?
So that shouldn't be a problem if they're laid off because as per AC21, even if you are allowed to change employers, so you would simply have to then find another employer that's willing to sponsor you. So as long as, at every given point of time, your 485 has to be attached to an offer of permanent employment. So as long as that happens and that is taken care of, you should get your green card by, using AC21 and switching to another employer.
Right. So when can one file for the I-485 adjustment of status, Ms. Reddy?
Well, you file for the 485 once your I-140. Actually, you can file for I-140 and 485 together, second and third stage together. But so I would say that you can file for a 485 once your visa number becomes available. That's when, and your perm has been approved, your labor cert has been approved. That's when you can file for your, I-140 and 485 concurrently, or if your I-140 has already been filed and your visa number is available, either based on dates for filing or based on the final action date. As we know, there are two visa bulletins that come out, two charts that come out every month. So if your date is your priority date, that is the date of filing your labor cert, usually that's the date, which is called the priority date. If that date is the same or after the priority date that is on the visa bulletin, then you can file your 485.
Right. Right. And what kind of I-485 RFEs are we looking at right now, Ms. Reddy?
So the 485 RFEs that we're looking at is a lot of them are for medicals, because even though they submitted medicals earlier, because of COVID, USCIS has new requirements, so they want everyone to be vaccinated. So they're sending out a request for new medicals with the COVID vaccine, with the proof of COVID vaccine. So we're getting a lot of medicals, RFEs for medicals. You also get RFEs for birth certificates. That's not uncommon. Usually when applicants don't have birth certificates and we submit secondary evidence, or when they have birth certificates but they've been registered much later, not at the time of the birth, then they again ask for secondary evidence. So it's not unusual to receive an RFE for birth certificates. Sometimes you also get an RFE to show USCIS asks for proof of status, especially if you haven't submitted your recent I-94. They might ask for all recent I-797 approvals and the I-94. So that's another common 485 RFE that we often see. And the ones that are not so common are the ones that where if you have some kind of a criminal case that has been filed against you, then they might ask for more information with reference to documentation on that case, and if it was resolved, what the judgment was, and if they want you to show how you still qualify for the 485 under, because there are certain exceptions even for people who have been convicted of a crime. There's a petty offense exception, so they want to see if you qualify for that exception or not.
Right. Right. So with that, Ms. Reddy, we come to the end of the session, and thank you so much for being on the show and explaining to us very patiently all the important updates and their significance and their repercussions. It was a pleasure hosting you, Ms. Reddy.
Pleasure as always, Tony. Take care.
You too. Thank you, Ms. Reddy. You're watching Sakshi TV Live. Thank you.